domestic violence cases. I've talked to you before about domestic violence cases, but tonight, I'm going to talk to you specifically about waivers of prosecution. What's a waiver of prosecution? It's a document, it's a very simple document where the alleged victim, right, the person who was allegedly struck, touched, punched, kicked, whatever, in a domestic violence case by a member of their family, a loved one, or someone that they're in a relationship with, and that person, that victim, that alleged victim, signs a document, it's an affidavit, and it asks the state attorney's office to waive prosecution, to say, look, I'm not injured, I'm not hurt, I love this person, I want to try to work it out with this person, I do not want this person to be prosecuted, I don't want this person to go to jail, I don't want this person to go to prison. So how does one inquire about a waiver of prosecution? Well, as crazy as this may sound, folks, and I know I've said it before, I would say 95% of the time I'm hired on a domestic violence case by the alleged victim, the person who was allegedly punched or struck or kicked, right? I'm hired by them. So when they come to my office and say, hey, my boyfriend's been arrested for battery, I'm the one that they say he hit, well, that person's in my office. It's pretty easy. They say, what can I do to help? And they hire me. And I'm not allowed to tell them what to say. I'm not allowed to tell them what to write. However, I can give examples of other cases that I've had. And then they have to write a narrative, a statement that explains what happened. And a lot of times those statements revolve around mutual combatants. What are mutual combatants, right? Well, the man, let's say, gets in trouble for smacking his wife or throwing, I don't know, food at his wife, right? That's a battery. Could be an aggravated battery depending on what he throws, but let's just say a slap or a push, right? Well, then we may find out through that waiver of prosecution that the alleged victim, that the woman in the case, or the man, whoever the alleged victim is, that they actually pushed the defendant first, or punched the defendant first, or tried to stab the defendant first. And then you have a mutual combatant situation. And when the state attorney sees that there's mutual combatants, that they really can't tell who the initiator was, or that maybe the initiator was actually the alleged victim, most of the time, the case goes away, meaning the case gets dismissed. Another way the case gets dismissed is when the alleged victim is writing their affidavit, their waiver of prosecution. They may say, listen, I was drunk, or I was smoking a little bit too much that night, and I was under the influence, and I was paranoid, and I don't really remember, and I think I hit him first, or I think I hit her first, or, oh, you know what I did? I was drunk and I was gonna leave, and my husband, blocked the door to prevent me from leaving so I wouldn't drive while I was impaired. Well, that might be a good reason for the state attorney to drop the charges, right? Or another reason could be, I told the police my story. I told them that I was never hit, but they saw that I had a mark on my knee, or they saw that I had a mark. I tried to tell them that I fell skateboarding or surfing or running and I tripped, but they didn't believe me, and they arrested my boyfriend or my husband or my girlfriend or my wife. But that's not what happened, and they write that in a narrative. And then that's a good reason for the state not to prosecute. So there's a lot of reasons. Again, mutual combatants, I would say, is probably number one, with a very close number two is that I was under the influence of drugs or alcohol, and my memory is not so good of really what happened, and I think maybe I was the aggressive. So maybe that's a combination. That's a reason that a lot of my cases have been dismissed. The other one is that, hey, the police didn't listen to me. I told the police that he or she didn't touch me, but they said that if they have to come out for domestic violence, they're going to arrest me. So they tell their story. Now, when I say tell their story and write a narrative, folks, I don't mean they write a long story. They don't write a novel or a novella. They don't write 5 or 10 pages. They keep it simple. It's a couple of paragraphs, maybe a page and a half. more than that, the state doesn't really want to listen to all that. They're not in the book reading business. They're in the prosecution business. So I told you 95% of the time it's the victim that hires me. What happens the other time? Well, because there's a law and there's a no contact order between the client, the first thing I tell every single client, right, the defendant, do not contact your husband, do not contact your wife, do not contact your girlfriend or boyfriend, because if you do, you can get another charge. You can be held in contempt. You can be charged with violating a no contact order. You can end up with a stalking charge even. There's lots of things that can happen. You also cannot tell your best friend or your brother or your sister, your mom, your dad to say, hey, call Sue and tell her to call Foley. You can't do that either because you're asking a third party to do it for you, and that's not allowed in a no contact order. So how the heck does my wife or my girlfriend or my boyfriend or my partner, how do they know to contact you? Well, doesn't mean that the defendant can't share their story with friends and family. They just can't ask those friends and family to contact the victim. If they share the story and that person says, you know what, I'm going to call their attorney and see if I can help them. Well, folks, that's how the other 5% find the attorney, and not just me, but other attorneys. I'm sure it's pretty similar, right? And then that alleged victim contacts, like in our case, they contact my office and they say, hey, you're representing, my boyfriend or my husband, or you're representing my wife, and I want to help them. I don't want them to be prosecuted. And I told the cops, but they still arrested them. What can I do to help? Can I come in and talk to you, Mr. Foley? And I go, sure. And they usually come into my office. They say, what can I do? And the first thing I tell everybody, right, is I say, I cannot give you, the alleged victim, legal advice. No legal advice for you because I'm representing your significant other or family member, right? I cannot give you legal advice. I can share with you other cases, sort of the examples of mutual combatants, being under the influence, telling the police, those are probably the 3 most common reasons cases get dismissed. I can't read what you wrote and go, oh, add this or add that. I am not allowed to do that. So I explain to you other examples that I may have dealt with myself. And then you tell your story. You, your significant other, the defendant, and the man upstairs are the only people who know what happened in your case. So you write the narrative. I don't comment on it. All I do is make sure that document, that waiver of prosecution, gets in the hands of the prosecutor on the case, or the case filing attorney or case intake attorney, and or the judge. Because if the case intake attorney has it, we got a real good chance of making the case go away before the defendant even goes to court. If they still file because they think they have enough evidence regardless, that statement may end up being used in court to help the defendant. So it has a duplicative, it has 2 different ways to help the defendant. So that's what a waiver of prosecution is. No attorney should ever tell you what to write in the waiver of prosecution. No attorney should be checking and go, well, maybe you should add this, or maybe you should take this out. We're not allowed to do that, because if we're doing that, then we're technically tampering with a witness. We're committing a crime ourselves. And I'm not going to risk my bar license for any client. I will zealously advocate, but I will not cross the line. I expect other attorneys to do that. That's waiver of prosecution. I'm attorney Roger P. Foley. If your significant other is charged with a crime, you may want to contact their defense attorney and see how you can help the defendant, your loved one. Thanks for listening.